Greetings and salutations from Nashville, Tennessee. I'm up here seeing a friend and conducting a few interviews. Today we're talking with A.J. Koenig from Phoenix, Arizona. He's got two traffic matters in two different municipality courts. One has been dismissed and the other one is ongoing. He's been convicted and he's in the appellate process for that. So we're going to be talking with him today, getting all the deets. And it was a really good conversation. He's in Phoenix, Arizona, and he's a go-getter. So without any further ado, let's get to it. Here's AJ. Welcome to the Legal Beagles, AJ. Thank you for being here.
Thanks for having me, Gary.
Good to have you. I do apologize for the color settings out here. Everything's a little bit different when you move. I apologize for that, but let's jump right into your cases. AJ apparently has had some traffic citations. Is that right? Or what kind of citations are they?
Yeah, the municipality, they call them criminal traffic violations.
Oh, right,
so
right.
I'm a real bad guy.
Quasi-criminal.
Yeah, they call them criminal. They're not in the criminal code. They're of course in the transportation code. But I think they call them criminal just so that they can. I don't know actually why they do it. It gives them maybe they think it gives them cover to violate rights in different ways. But and they fortunately follow the rules of criminal procedure according to, or they're supposed to at least.
Right.
So that makes it a little bit easier when it comes time to fight, because at least I have a prosecutor in Arizona. Municipalities, if they're calling it civil traffic, they don't even pretend like it's not purely administrative, the hearings that they go after. The municipalities, when they call it civil traffic, in those ones you don't have any rights. If you go to trial, all it is an administrative hearing. The cop shows up, the judge shows up, and they convict you. Like, that's all that happens. There's no rules of evidence. There's no formal procedure. There's nothing. It's just collect a bunch of money. If they call something criminal traffic, then they have at least the rules of criminal procedure that they're supposed to follow, and there's a prosecutor, and there's should be some process of law. My experience, there really isn't, but at least there's something they should adhere to.
Right. Yeah, the municipalities definitely are. Like Alphonse created that new, I don't know if you saw, he posted he's going to have municipalterrorism.com or something like that, and start posting some information on there. So they are the biggest violators of rights across the board, and they train their city employees to do this, and knowingly or unknowingly they're doing it, and it's something we're going to have to deal with and beat them back.
Yeah, I think I kind of I've concluded at least that they don't train them, and they don't train them intentionally, because if the officers knew like just how bad they're violating rights every day, like I think most people are moral. Most people, they have a compass inside that tells them right from wrong, and they wouldn't be able to do the things they do if they had a clear understanding of just how wrong their actions are as it relates to treating the soccer mom or anybody who's just going about their business. I don't believe that they are intentionally jackboot thugs. I think it's some people are. Some of them probably are, but I think that most of them they have some level of delusion or mistraining or untraining, so that they can keep doing this stuff and not and still sleep at night. Because if they really knew it, the movie's telling us that there's these government officials who can't wait to violate our rights. I don't know if that's real, but I don't think that's how people really are most of the time. But if they think they're doing right, they sure can do wrong. The busybody who thinks they're moral is the one who's going to ruin your life.
So, were you interested in studying all this law before you got these citations, or did you get the citations and then start? How'd it go?
I probably have some roots that go back a long ways that help give some nourishment to this stuff. So, like, just to throw out a little bit of pedigree, and I don't know, if this is of value or anything. One of the papers I wrote when I was in college back in the early 90s was on the 16th Amendment and the law that never was. I lived in the same town as his name, Red Skelton, one of the co-authors of that one. So it was, how the 16th was never properly passed. I have like one of my uncles was he brought some gold up to help out the freemen when they were holed up in Montana in the early 90s. Like I've got some roots that kind of question some things going back. And I think I bought in a lot to the more of the patriot mythology side of things before I got like actively involved. I was like, they don't have a right. I would very strongly do these things, but as far as how to actually go about doing anything, I it wasn't until I was really dragged in that I kind of buckled down. Like I got jurisdictionary a couple years ago, probably 3 years ago. And went through it pretty quick, but I didn't do anything with the information. I was like, well, that doesn't apply to me. So I pulled plates off my truck and rolled around plateless for a year.
Well, it's better to be prepared for when it happens. Brett was going into that. Just it's good to know all these things before you get into a problem. But it's funny you bring up Red Skelton. I am distantly related to Red Skelton.
Oh wow.
for whatever usefulness that is, but thought it was funny. No one speaks of him, so I thought I would take the opportunity. But okay, so you get the traffic citations. What's the first thing you do?
And
you got them in tandem, right?
Well, not exactly.
Okay.
I got one citation. I was involved in a collision that wasn't my fault, and when the police showed up on scene, I declined to interact with them because I'm not required to by statute. I don't have to do anything with them. And so I told them directly that I wasn't going to. I was going to handle it directly with the other parties who were involved. The supervising officer on the scene, whatever his stuff was, he's like, well, this is the statute you must follow. I pulled it up on my phone right there and read through the thing. I'm like, okay, so I'm reading this. This says I have to exchange information, do this. As long as I do this stuff, I don't have to do anything with you guys, right? And he's like, well, comply. And I was like, I just read it. We just went through that. And he's like, yeah, that's correct. So I went about my stuff, interacting with the other parties. And then a younger officer on the scene showed up and wanted to have more of an interaction than I, was willing to. And after I told the supervisor to get his guy in check because he was, stepping out of line. And then he went and my truck that I had been driving, I parked it in a private parking lot, cleared the roadway, got it over there. He went over and took it upon himself to conduct an investigation on private property with no exigent circumstances and no warrant, allegedly in the enforcement of transportation code, even though he had there was no transportation code he could enforce because he didn't witness any activity that would fall under that. And he came up with a violation that he felt like had occurred. He approached me and wanted to question me, and I stood on my Fifth Amendment right against self-incrimination, and he arrested me. So that started one. When that started, this probably isn't wise. I don't recommend this. I just ignored the stuff. I didn't do anything with it. And then I was picked up for a bench warrant 6 or 7 months later. And that's when I kind of started having to actually address the stuff. And then maybe 4 weeks later, I was pulled over for a expired registration ticket or sticker, and that started the stuff in the neighboring municipality. So that's how I had two ongoing at the same time in different municipalities. One of them was, I ignored it.
And which two municipalities are we talking about, and where do you live?
Oh, Gilbert, Arizona, and Chandler, Arizona. These are suburbs of Phoenix.
Gotcha. Phoenix, Arizona. Here we are. We are.
Yep. That's why I'm inside instead of outside, because where I'm at, it's very hot right now.
Yes. Already. I'm in Nashville, Tennessee, and it is very, very pleasant today. So I thought I would sit out on the deck and conduct the interview. So did you do public requests for records first? Did you how'd you get all the information from them? What's your next step after? They didn't arrest you, right?
So I was arrested for not answering questions in the first one.
Okay.
He arrested me, and then I signed the promise to appear, so that so I wasn't in jail any longer, and got released from custody. And then I didn't appear. So that's where the bench warrant for that one came from. In the other matter, where I was driving down the road minding my business, he he pulled me over, and I offered my I offered my passport as by way of identification, because I know that they get real antsy if they think that you're failing to identify. So I gave him my passport, and I directly informed him that I was not engaged in transportation. The purpose of that was to rebut his presumption that he was enforcing the transportation code.
Mm-hmm.
And theoretically, he's then supposed to get some evidence of something. They don't do that. If he thinks he's got that presumption that he has a reasonable, articulable suspicion, even if you rebut the presumption, they don't have enough training to know what they're supposed to do or required to do at that point. So that one, I on the side of the road, he wanted proof of insurance, and he wanted all the things that he wanted: driver's license, insurance, registration, all that. And because I was not engaged in transportation, I wasn't providing any of that stuff to him. That one ended up, let's see, called in backup. I had 6 officers surrounding me, parked in front, parked in back, all over the place. And when he brought back the ticket, sign this, you're not saying you're guilty. I'm like, well, or I could be brought before a magistrate for a determination of probable cause. And he's like, if you don't sign it, then yeah, you can be arrested. And I was like, no, it's brought before a magistrate. Like, that's what the law says. That's what you're required to do. And he and his friends, he opened the door to my car. And when I climbed out, they grabbed me and shoved me against the car as I was trying to lock it. And I think he did that specifically so they could try to add resisting arrest to the stuff.
Mm-hmm.
But what he messed up on, which I found when I got the body cam footage, because they're required to provide you, like the prosecution in a criminal matter has to disclose. They are required to disclose a bunch of stuff. And one of the things that I got is at least 3 officers manhandling me prior to him informing me that I was under arrest. So that's going to be helpful later on.
So assault.
Yeah, I say that's assault, and I think that there's no real defensible position they can take for it not being.
Right.
But I did not do any records requests. I did research into standing orders for the police departments. I looked up the stuff, and then my goal throughout was to use the rules that they have, the rules that they are required to follow, to see if they're going to follow the rules and to make them follow the rules. So I just used court rules to get the stuff that I got, and their lack of following the court rules to determine the next steps.
So which one did you get thrown out, and then how quickly did that happen?
The city of Chandler, which was the one where I had the bench warrant for a time, it took, let's see, it took about 6 months for it to wrap up, from when I was arrested to when it was dismissed. In that one, there were multiple hearings, and I filed a motion to dismiss that was based on the one that Brett Fountain, who's been on previously, based on what he filed into his case, citing the reasons why: deficiency of the charging instrument, failure to properly invoke jurisdiction of the court. That one, the judge refused to address it in a hearing that I was at, and just kind of steamrolled. And then eventually, probably 2.5 months after I filed the motion, the prosecutor filed a reply, or a response rather, completely off base, moving to strike much of the stuff that was in there. And then when I did my reply to theirs, pointing out how they were not timely and how their argumentation wasn't on point, the judge then took the opportunity, ruled against me, and denied my motion, and then proceeded. But in that one, I had, because that's what they do. I had 5 or 6 hearings. All of them just resulted in continuances. And at each hearing, I kept bringing up that they weren't doing what they were required to do. So they have a hearing and they try to get me to plea, and I won't. So then they enter a plea, and they have a hearing and they try to advance to, schedule a trial. And I'm like, you're required under Rule 15.1. Like I cite the specific rule. You guys have to give me the evidence that you intend to use against me. Where is it? And the judge then grants continuances because, oh yeah, they are supposed to do it, but I'm not going to dismiss because they won't. Although they'll happily convict anybody who doesn't know that that's what their rights are and that that's the duty that the prosecution has. Um, so that one, it just kept getting continuances and evidence. When they did finally provide evidence, the only video footage that they gave me, and I was hoping to get all of the evidence because it would clearly show the rights violations that occurred on the side of the road. But instead, all of the body cam footage from before my arrest and like the only body cam footage that they provided was after I was released from custody. Somehow magically, the police lost all of the footage that would have directly incriminated them in different things.
Yeah, yeah, that sounds about right. And did you by any chance think to give them a notice to preserve evidence for your future possible federal cases?
I did not think that at the time. I wasn't on the ball enough in my personal stuff. Like it wasn't as much of a priority because of other things. Um, if it were to happen again, I would do that. But even without that being the case, something that George Gordon, who's got some stuff from the '80s that's really valuable, I think, has put forth is the negative inference jury instructions. If they're required to have something and they don't have the thing, then it can be appropriately inferred that the reason why they don't have it is because it would be bad for them.
Right.
So, like the police deleting footage or, oh, our bad, oopsie, it was flagged wrong. So that's why it got deleted. Well, you're required to keep it and you didn't keep it. So, that's kind of crazy. But what I also learned by reviewing their standing orders and kind of like really getting dialed in on what they have to do, what there's all that stuff. There's a police legal liaison. Like there's an attorney that works for the police department, and their only job is to protect the police department. So they review stuff before it goes to the prosecutor. They review stuff before disclosure stuff takes. Like they're already lawed up, and I suspect they're going to claim that it's a work product and stuff, and that's why they can't disclose it when I get into my suit. But yeah, like they're already in a very secured and defensible position because they know that the people that are out there don't know what they're doing.
Right. And that's something we're going to have to think about moving forward. Like, how do we prevent these erasures of videos that are damning to the police? If it's upload to the cloud by a third party or a blockchain maybe, or something that just can't be tampered with, that's something we need to think about for how we want to change the system as we make progress in this arena.
Yeah, and I think I don't believe it's actually gone.
Oh,
Like
sure.
it's one of those things where, nowadays there's access to this stuff, but because of, they'll of course claim that it doesn't exist, and they'll make all the claims that they want to make. But like in this era, there is no, forever disappeared. And it's really going to be a matter of how much do they want to pretend like it doesn't exist. And so like, as when I go on the offensive, I'll be citing and putting together something that I hope will put them on their heels enough that like I don't think I'm going to change the world in that municipality, and based on how they conducted themselves, like specifically how the court conducted themselves in this is Chandler, city of Chandler, how
Hmm.
they conducted themselves. It's fairly clear to me that they've been sued and they've been put on notice of what they can and can't do, at least at the court level. The police were, heavy-handed, but they always are. So I don't really expect anything different there. But the courts at least handled themselves fairly well. So like they know when they mess up, and I think, well, and I'm not sure about this. As I go on the offensive, I'm going to try some maybe some different tactics than what others have done in the group, and see if I can maybe get some declaratory judgments, like to supplement my rights violation stuff, just to have stuff that they can't pretend like things didn't happen that did.
Right.
So that'll be a future thing. Even without the footage, they're still in the wrong.
And what's the statute of limitations over in Arizona?
It's 2 years.
2 years. And would that be from the end of the trial or from the incident? Is there tolling there?
I don't know specifically on that one, and like
Just something to be mindful of. Just something.
Yeah, yeah.
Yeah.
I can get it initiated within 2 years regardless, but I'm kind of keeping that in mind that's where my stuff is, just to get that ball started before it's too long out.
And so some of the fastest way up the chain is through injunctions. Even if you file the complaint, you can file a separate, injunction to make them stop doing their behavior. And you'll probably get denied, but that order can be appealed immediately to the next circuit and up the chain. And that's what Saraf has done, and we attempted to do, but we were a day late because of, well, it doesn't matter. But anyway,
yeah.
So that's so they threw out the one in which county? I can't remember. Grant.
Yeah,
in
Chandler, the prosecutor
okay.
dismissed charges when it became clear that the evidence that they are required to have did not exist.
Right.
And what I also got is, and I kind of treated both of these, once I knew I was in the right, just as evidence collecting opportunities. And that's why I didn't pressure them as much to resolve it. Like I wanted them to give me the footage. And then when it became clear they didn't, they actually dragged their feet until it was outside of 12 months from the incident, because their records retention stuff requires them to keep the video for 12 months.
Mm-hmm.
So even though I pointed out, hey, you guys owe me this footage, and I did it months before they should have deleted it, or could potentially have deleted it. Like they couldn't delete it while there was an ongoing matter, but they could pretend like, oh, we didn't know, therefore. They didn't tell me that it had been deleted until it was like 12 months and a week kind of thing. And they did 2 continuances in the meantime. But then they claimed that they deleted it more than 6 months beforehand. Like they claimed that the footage got deleted before there was even a hearing in the matter. So whatever it was that they were doing, it's in violation of rules retention law. It's in violation, like all kinds of stuff. And they never had anything that could justify what they did.
Yeah, I think with the a lot of the COVID matters and things of that nature, we're going to start seeing, as these statute of limitations disappear across the nation, you're going to start seeing movement on a lot of those cases, and they'll settle them, but it'll be too late for the masses.
Yeah.
Yeah. So.
Yeah.
Let's jump into your second one that is ongoing, and I'm sure that's pretty interesting as well. What did they do wrong there?
So the second one is kind of fun. That's the one where I was arrested and assaulted for not signing a promise to appear.
Right.
They took me into custody, and rather than bringing me before the magistrate as required, they locked me up. I requested, or I don't know if I requested, I think it was maybe more of a demand. I demanded of the jailer to be brought before the magistrate, that they could make a probable cause determination. And I just did that, for the record. Like it shows me on the video of whatever they have in the jail, making that demand. And they told me, you can be brought before him in the morning. That's when it happens. So I was in jail overnight, with all the fun that goes along with that. In the morning, let's see. Oh, yeah. In the morning, shackled up, brought into the courtroom before the magistrate. And I had just been kind of thinking about what I would do, how I would present it. And when I got in there with the other gentlemen who were also in there for whatever their reasons were, when I went before the judge, he started trying to get me to plea. And I pointed out, I'm like, well, I've got concerns about due process, because I don't even know how this court acquired jurisdiction. And like it has to be properly vested before the court can do anything. And he's like, well, everything happens the way that it's supposed to. And I say, well, no, because I've been reading some statute recently. And he's like, oh, you're a couple weeks of studying statute versus my 30 years of practicing law. And I'm like, I'm not saying anything about that. And I start, trying to elucidate. And I had remembered that there's a specific statute, 13-30.06. I'm like in my mind wanting to reference the exact statute that says what they must do in the event of an arrest without a warrant, which is what it is. There's if there's an arrest with a warrant, then there's already been a determination of probable cause. A judicial officer has already determined that there is probable cause to make an arrest. Most arrests that happen are arrests without a warrant. And in that case, the officer is the only one who thinks that a crime exists. They're the one who's making the determination. And they're doing that because they've been statutorily granted authority if they witness a crime. But they don't know what a crime is. They think
Right.
everything's a crime.
Right.
And because they think everything's a crime, they think that they can arrest anyone for any time for any reason. And because we don't know what the requirements are in a warrantless arrest, and we don't know how to keep them accountable, they just keep doing it. Well, in this instance, I knew the process. I knew what was supposed to happen. But when I told the judge that it wasn't happening, he cut me off as I was talking, had the bailiff or the jailer, whatever, he's like, we'll try again tomorrow, take him back into custody, and ordered me out. And I protested, and I think I voiced that I asked him, are you denying my right to be heard in this hearing? Because we always have a right to be heard. But he just said, we'll try again tomorrow. So he ordered me back into custody downstairs, and then I bonded out because I had the money already. I was collecting rights violations at that time, seeing
Sure.
how they do.
And just out of curiosity, was this via a Zoom meeting, or was the magistrate in the jail, or?
No, this was in person in the municipality. There's the police department has a deal like situated here, and then they share a wall, and then there's the jail or the courthouse. So they share a wall, and they share a parking structure, and they share all kinds of stuff, but technically it's two different locations. So they walk you out a back door on one and in a back door of the other, and then you're in the different place.
Mm-hmm. So
Yeah.
how much was the bond, can I ask?
That one was 300. And then I had a few hours after I got released from custody, and the hearing was the next morning. So I got to work trying to figure stuff out. And I was looking up statute, and I was looking up all kinds of things and posting in the log group. They did this, they did that. And Brett Fountain, the hero of moderate, holding them to the rule of law,
Right.
he chimes in and he's like, all those are fine. Have you read your Constitution? And he really, helped to bring me back into it, because he's like, it doesn't matter what the statute says if the Constitution says something else. In Texas, it says they have to have this. Do they have it? And I look in the Arizona state Constitution, and it says what they have to have, and they don't have it. And then I start reading some more, and I was like, oh, holy moly. Using nothing but the state Constitution, like I can prove that they did wrong and they are out of line using nothing else. And that, for me, that just like everything became immediately clear, because it's confusing going into all the statutes. It's confusing going into all the rules. It's confusing going into all the case law, because like in reality, that stuff's not for us. Like it literally isn't.
Right.
And until I got that clear moment of illumination, I was, kind of floundering a bit. And then I saw, well, no, like if it doesn't make sense to Joe on the street, it doesn't apply to Joe on the street. It can't. They can't say ignorance is no excuse. Ignorance of the law is no excuse if the law is not comprehensible to someone to whom it is meant to apply.
Right. And it should be that simple, that the Constitution protects those rights, and the statute can't say anything different than the Constitution. And if it does, it should be stricken from the record. But that requires challenges and all of that, of course. But yeah, it should be that simple.
Well, and the fun thing is that we get confused and we get kind of off base sometimes. And caught up in the weeds, and I think that like that's the pro se trap that has been sometimes discussed. But this is an excellent ruling that I think we maybe need to use a lot more of, and it comes from my home state, Miranda versus Arizona. We all know that one. Just this one line: where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them.
Right. That's right. That's absolutely
Just
right.
that plus the Constitution, like that wraps it all up. But then they say, well, we can do this and we can do that. No, you can't. You can't. Unless you can prove that, like, you want to enforce transportation code on me, cool. Prove that I fall under transportation code. Because I also I had, in the interim, I had gone through all the trainings from George Gordon, and his one of the things that he preaches is to make them prove everything. You know, if they say that, that I'm wearing a red shirt, I object. Prove I'm wearing. Who told you I'm wearing a red shirt? Where's the witness of that? Like that kind of belligerent and not conceding any points to anything attitude, I think is something that we need to really get dialed in on, because they cannot provide evidence of anything that they do that meets the rules of evidence. The officers don't know anything. They can't testify to things that they don't know about. They don't have training. They're not expert. Like, there's all kinds of things that day in and day out happen in the courtrooms, and because we don't know how to hold them to account, it keeps going. But it's a thing where, to me, we have to do it individually. Like, I can't do it for another, and another can't do it for me. If I'm willing to let somebody violate me, well, you know what? I let it happen. But if I care about it and if it's important, then I get the opportunity and I have access to the information where I can do something with it.
That's exactly right. It's up to you to defend your right, to know your rights and be able to defend them. If you don't, you have none.
Yeah.
You have none.
Yeah.
Okay, so continuing on, what happened next?
So continuing on, I prepared a motion to dismiss before the first out of custody hearing. It was based on Brett Fountain's motion to dismiss, jurisdictional challenge, venue challenge, prosecutorial misconduct, variety of things listed. I went into court thinking I was in pretty solid footing, and the judge would not, like, she cut me off as I was talking, got loud and argumentative. And the thing I noticed is that when I was in there, she was getting kind of noticeably frustrated with me because I wasn't just going along with the process that she wanted to do. But when other people got brought into the courtroom and I was still not just bowing down before her, she lost it. She got, yelling and freaking out and all kinds of stuff. And the audios of all this is posted in the Alphonse Fagiola group. If anybody wants to hear this stuff, I've got my stuff posted. People can search me out by AJ in the group and listen to the audios. They're pretty fun.
Are all your documents labeled AJ, and how are they labeled so you can find them?
The easiest way is to search using me. So just into the search function and then select the person, and the person is AJ.
Okay.
I don't think there's another AJ in there. And they're labeled differently. I gotta get a better labeling system or adhere to one, because right now my stuff is kind of a mess. She actually assigned me a public defender for a time because I wouldn't just go along. I didn't realize it at the moment, and I tried talking to the guy before I realized that he was assigned to me. Just talking to him like a regular fella, and this is where I brought out the stuff from the state constitution, because I had read the Declaration of Rights in the Arizona state constitution, and really, like, all I was trying to do was get them to either prove that they had jurisdiction or acknowledge that I have rights, one or the other. And I found these several things. It seems like our screen sharing isn't working, so I'm going to read just a few of the things from the Arizona State Declaration of Rights, and all of the states have something similar to this. Okay. First one is Article 2, Section 2. All political power is inherent in the people, and governments derive their just powers from the consent of the governed. And governments are established to protect and maintain individual rights. That is the only purpose of the governments. And every subcategory of the government, whether it's executive, legislative, or judicial, if you go into their the acts that establish them or the constitutional provisions that establish them, it says the same thing. They are to protect and maintain individual rights. That's why they exist. Article 2, Section 4, no person shall be deprived of life, liberty, or property without due process of law. Some of the ones that I found to be kind of interesting for later. Article 2, Section 23, the rights of trial by jury shall remain inviolate. Any charge that does not allow a right to trial by jury can't be for me because I'm one of the people. Oh, this was something else in the hearing. The judge from somewhere got the idea that I was a sovereign citizen, and she called me that in the thing. She's like, I get that you're one of these sovereign citizens and you think the law doesn't apply to you. And I said, I'm one of the sovereign people of Arizona. And she didn't have a response to that. But like, I'm pretty convinced they undergo training on how to violate the rights. I don't know how to treat people who are, as the government identifies them, sovereign citizen, and then they use harsher tactics on them to keep everybody else in check.
Yeah. Yes, I've actually seen prosecutors hand notes to the police officer ahead of time, and they actually used it to eliminate their own video. Well, video is only two-dimensional, and it can't capture the three-dimensional aspect of what the officer was seeing on the scene, and so this video is invalid. What?
Wow.
What? I mean,
so they invalidate their own video.
Yes. It's unbelievable.
Well, and video is like audio and video are kind of hearsay anyway in court. That's the thing that's like we want to think that video this proves that it happened. Like in my other matter where the video got deleted, it doesn't actually matter that the video doesn't exist because what happened. So whether I have him on video violating my rights or I just testify that he violated my rights, he still violated them. And I have a witness that was there that saw him, like watched him put me under arrest, specifically when I didn't testify, like volunteer to testify against myself. Just that by itself is Fifth Amendment violation, you know? And it's a state crime, I later learned. Another constitutionally declared right that exists in Arizona, Article 2, Section 30, no person shall be prosecuted criminally in any court of record for felony or misdemeanor, otherwise than by information or indictment. That right there is kind of the golden ticket when it comes to the municipal charges and the traffic stuff and all the things that they bring against people everywhere. An information is when a prosecutor has reviewed evidence that has been collected of some investigation that occurred by somebody, and then they put together an information that says these are the things that happened, this crime has been committed and it was committed by that guy, so they have an information. And then an indictment is a grand jury indictment where a jury of our peers has come together, has been presented with the information from a prosecutor of some sort, and has determined that a crime has been committed. Those two things are the only two things that are constitutionally acceptable to prosecute and to initiate a criminal matter. That's it. There isn't another thing. In the rules of the court and in the rules of criminal procedure, they add a third one that is a complaint. And that's what they pretend like they're doing. They pretend like traffic tickets are complaints. They pretend like the officer's feelings on something are complaints. They pretend like they have the knowledge to do a complaint. And that's how they kind of get away with starting things. In this matter, and what I found is that they don't even follow the rules as it applies to complaints. And I'll kind of get into that in just a minute. I'm going to back up a little bit in the story. So these provisions that I had, I went through these with the prosecutor that had been, or the defense attorney that had been assigned to me, and he politely listened, I think because he's getting paid, and then told me that those don't mean what I think they mean. I said, well, how can they mean something different? Well, maybe you should go to law school. And I was like, why do I need to go to law school to read English? Like, I can read. If it means something different, tell me how and why. But if it doesn't mean something different, then this clearly doesn't apply to me. Um, and he didn't really like that, got frustrated. And I got frustrated too. But then I realized that even if the court won't allow me to speak, I still have my filing, that, like, my motion that I put together. And I went downstairs, went up to the clerk, filed it in. And then I was like, okay, even if I'm not heard vocally, I've got it on record. I have filed my motion to dismiss, my jurisdictional challenge, and that's where it's at. So I went upstairs again, back into the courtroom, and in the meantime, the prosecutor had offered to dismiss the charges if I just accepted, like, basically they would dismiss charges for time served because I'd spent overnight in jail. I did not accept that. I kind of had words with the defense guy over why he was acting on my behalf, because I didn't hire him and I didn't want him and I didn't need him. But ultimately, he asked the judge to be dismissed, or to be released from that thing. I gave a copy of the motion I filed to the prosecutor, and then it was scheduled for the next hearing. Had multiple other hearings, ran into the same issue where the prosecutor didn't disclose stuff, didn't provide stuff timely. The judge thinks that things are, we're going to trial. And I'm like, they haven't disclosed anything. And they scramble and check their notes. And the prosecutor can't say who the person who filed this thing that claims that something was mailed when it wasn't, who that might be in the office. Ultimately, it's just continuance. Eventually, this matter goes to trial. Sorry, this part's kind of fun. The woman judge got flustered when I wouldn't just bow down before her, and tried to have someone else come in. But someone else is he's like the heavy in the court. He's the guy that's the enforcer. In a hearing before him, this guy is demanding that I acknowledge jurisdiction with no evidence that the court has jurisdiction. And I'm asking what evidence there is, what they've got, how they acquired it. And he says, do you accept and acknowledge the court's jurisdiction? And I say, no. And he orders me brought into custody again. So at like the third hearing, I got sent into custody again for not just blindly accepting jurisdiction. I bonded out, that resolved itself as well. But that is the judge who eventually I had a bench trial in front of.
Interesting. It's interesting that that these municipal courts are even entertaining anything constitutional, because a lot of them just don't bring that Constitution in my courtroom. It means nothing, and in a lot of ways they're right. But
it's interesting that they violate rights so flagrantly, yeah. And then apparently, like, there's very little recourse. Like, I've filed judicial complaints against all the judges that I've appeared before for specific violations of judicial canon that they committed in my presence, and that I have on record. Like, I've got audio of them doing these things. With the woman judge yelling at me and doing all the stuff, the Judicial Commission researched it, and they determined she did nothing wrong. I'm like, okay, well, good. The other guy, the guy who had me taken into custody for not acknowledging jurisdiction where there was no evidence that it existed, his is still ongoing to my knowledge. And the fact that it hasn't been ruled upon, or it hasn't, like, there has not been a resolution yet, to me, that seems like it's maybe not so good, because hers got investigated and determined that she did nothing wrong in a very short period of time. And his has been longer than that, and it hasn't been resolved. So, we'll see what happens.
Interesting.
Yeah. And that's only from one hearing and one little piece. Some people have recommended filing complaint after complaint after complaint, and I'm kind of taking the approach now where I filed it in the process. I raised a flag on the field. Something is wrong here. This guy is doing wrong. and I sent it up the ladder to the Judicial Commission. If they, upon knowing that, don't do anything about it, it's not going to do any good to me. It doesn't seem like, to keep saying that over and over. So
Right.
I'm not gonna.
Right.
Instead, I'm just collecting the evidence and
Right.
putting it together, because once I raise that flag, if they keep doing nothing, well, I told you and you didn't do it, and then they did this and this and this and this, so I'm kind of um, just getting more stuff together so that I can slam them after everything is wrapped up. And then they can't say, "Oh, he's just disgruntled because he's trying to get out of something." Oh, no, I already got out of it, and now you get to justify how and why things happened the way they did, and how you allowed it to occur under your eye.
And
Um,
did you use any of these to try to recuse any of these judges, or you just made
I
judicial complaints?
I made the judicial complaints. I tried to recuse one of the judges, but I did not file it timely, because I didn't find the rule that specifies when it has to happen, because I'm not an expert on the rules. So by the time I found it, one of my first pieces of argumentation was, hey, the rule says this. I didn't find it until this time because I'm not a lawyer. I'm a guy who, like, I have my life. I have my actual things that matter, and this is a thing that I've been dragged into against my will, that I'm learning as I go. And it should be considered timely, even though it's not, because I found the rule yesterday. And as soon as I found it, I filed a thing. Well, the um, the magistrate in charge of the town's courts kind of mocked me in his reply or denial of that recusal. I was like, "Well, you should have known, because you found this, you found that," and it's like they've got this secret club where they know all the rules and the secret handshakes, and if you don't know them, then tough luck. And if you find them out too late, they're like, "Ha ha, you didn't know that you were supposed to knock 3 times and jump on 1 foot," and you don't get your recourse.
That sounds like the municipalities I'm familiar with for sure.
Yeah.
Just they just love the rules until they're not in their favor, and then they don't love the rules anymore, and then it's, "Judge, can you help us out?" And that's a lot of the judges do help them out.
Yeah.
But every now
Yeah.
and then we come across a judge that says, "Knock that shit off," and they do.
It's pretty wild how flexible they are on the rules when the prosecution is the one violating them, and how inflexible they are when the presumed innocent is the one who's not in compliance.
Yeah.
That to me is a very blatant difference in how they view everything. Like, the sign right outside the courtroom says, "You're presumed innocent." Okay, well then I stand on that presumption. Prove everything. Oh, we can't. So instead you're presumed guilty of this, whatever the things are.
Well, our officer said.
Yeah, and he knows something. So that matter had a few more hearings where things were not disclosed properly. The Eventually they got me all the evidence that they had, and the judge, in the meantime, scheduled it for a bench trial. I never waived the right to a jury trial.
Did the judge have to order them to give that to you, or they just voluntarily finally gave it to you?
Well, when I pointed out that it was never received, then they pulled up some piece of paper claiming that they mailed the evidence on a certain date, but it was signed by nobody knows who it was signed by. It wasn't recognized by anybody in the office, and there was no evidence that it went anywhere. And in the meantime, at my PO box, where I had received all kinds of other stuff from the court, I just didn't receive this thing from the court. So the judge gave them a continuance to prepare the disclosure items again. And then, rather than mail it out again, I opted to pick it up at the office, and they had it ready a couple days later. So I picked that up at the office. And then, as I was reviewing that, that's when I found the rule that says that I could disqualify the judge. But it wasn't timely. Like, she didn't do anything flagrant in the hearing. It was a very short hearing, in the most recent hearing, and the other ones were outside of the time frame. So one thing that I would say is very important to anyone dragged into any municipality: find out what rules they are operating under and read all of the rules. Don't read the ones that you think will apply. Read every single rule for that court, for that jurisdiction, so that you can know what all the rules are. Because the disqualification rule, it was located like instead of things happening sequentially, it was like Rule 58 or something like that, and all the things that have to do with the pretrial and the trial and the disclosure, those are like 1 through 20. And then Rule 58 says, oh, by the way, you can disqualify if you do it, and you have to do it within 10 days. Like that. That's kind of how the stuff goes.
Yeah, that's very sage advice to read all the rules. Make sure you ask them, hey, what rules are we operating under? Give them to me and read them all. And it could, because you never know what little slick trick they're going to try to weave in there. And if you know something about it, you most likely can do something to stop it.
Yeah. Well, and one of the other rules that I found that that would have been helpful if I was paying appropriate attention, as I mentioned earlier, a criminal prosecution, it can only start by an information or indictment. Anyway, so the Constitution allows for information or indictment to start a criminal matter, but the rules of procedure for the court rules of criminal procedure also allows for a complaint. But the complaint rules are very specific. It has to be a complaint sworn out before a magistrate. The magistrate has to make a determination of probable cause. Then things proceed. Like there's step-by-step things that have to happen. But then even after that happens, the prosecutor still must generate an information for those charges. Again, this is one of those high numbered rules that I didn't find until too late. They didn't do it. And by the time I found the rule, like I could have moved for dismissal on the 11th day after they didn't prepare an information, and they would have had to dismiss because it's a straight up rule that they have to do it. And I didn't find that until I was 3 months in, because I didn't know the rules beforehand. I didn't look specifically through the stuff. So like I would do it differently next time, but ultimately, it worked out. I got a whole bunch of stuff, and I got some things that I think will be they'll be very useful later on.
Yeah, and
Before the bench trial.
And the next
Oh,
people
go
next people that come behind you are going to know this because you came on here and told us about it. So it will be much harder for them moving forward. On every one of these that we push through the courts are going to disseminate information to the people, and it's going to be much harder for them to move forward.
Absolutely. Yeah. So prior to the bench trial, I moved to disqualify the judge for cause. Didn't do it timely, which was pointed out by the magistrate in charge of all this stuff. But she disqualified herself anyway due to the appearance of impropriety. Didn't want to do the stuff. So then the judge that presided was the same one who had me arrested or brought back into custody, arrested and thrown in jail for not acknowledging jurisdiction, which was an additional $100 a bond. So I got $400 to the state. And he wouldn't disqualify himself when I demanded that at the trial because of his bias. He also, just the way he conducted himself was like really shady. Like she came in, had some questions, whatever. When I said that I didn't think she could be unbiased, she recused herself and left. And then this guy came back in and just like came in kind of like a bulldog. He didn't identify himself. He just like thunders in and starts demanding that I identify myself. Am I ready to proceed to trial? And I'm like, who are you? Because I don't know who that person is, who that whatever is that's up there. He could be somebody off the street that just like accosted someone and then came into the courtroom. Unless he's identifying who he is and under what authority he's operating, I can't just accept that. But he just, let the record reflect. I asked 3 times and the defendant didn't blah, blah, blah. And I was like, okay, identify yourself so that I can know who I am before at this time. And he finally did. And I moved for his recusal or disqualification because of his bias that he demonstrated by having me arrested or brought into custody again. And he ignored that, and then it advanced. In the meantime, I had prepared a thorough motion to, or subject matter jurisdiction and motion to dismiss because the jurisdiction was never established. And I cited the constitutional lack of subject matter jurisdiction, that there is statutorily no subject matter jurisdiction because there's no it's an impossibility that what they have can apply to me based on the evidence in the record. And then a court rules subject matter jurisdiction failure because the rules on what must occur if they are initiating a matter were not followed. Um, the rules of criminal procedure say what must happen in order to start a complaint or to start a matter, and it says that the magistrate, upon receipt of an information, and we already know there was no information, or an indictment, and we already know there was no indictment, or a complaint, the complaint being a sworn out complaint in front of the criminal matter. And so they pretend like it's that third one, but then that third one has a subset of rules that they have to adhere to, and they didn't adhere to them. They just ignored them. The police didn't do them, the court didn't do them. And so I was like, you don't have A, you don't have B, you don't have C. Because you don't have any of these things, you don't have anything. You can't have them. It's impossible. And the prosecutor didn't have any position. He couldn't actually justify what they were doing because they had not followed the procedure for swearing out a complaint and what must happen. And then the judge, he read through the stuff, and then he reads through the statute and tried to figure it out. And ultimately, what he ended up doing before the trial started, before the bench trial started, he looked back through the record. He saw that at the initial appearance that was supposed to be a determination of probable cause, he saw and read in the record that there was no determination of probable cause that occurred months ago, read it out loud, and then said he would have made a determination of probable cause, but you didn't let him. I'm like, are you testifying? Were you there? And he, kind of smirked at me. He's like, gave me a look. I wish I would have said something about, let the record reflect whatever. But instead, what he did is he says, well, I'm making a determination that probable cause did exist at that time. And so in April, he makes a determination the probable cause existed in December of 23.
That sounds legit.
You can't do that. No, it sounds like what's the word? Something about falsifying a court record, like that sounds like the kind of thing that could really get somebody in trouble.
Yeah, like I said, just keep documentation, and then when you go into that federal court, it's gonna be a different story.
Yeah. So he did that. Decided that occurred in the past when he wasn't there, added it into the record, falsified the record in that manner, and then denied my subject matter jurisdiction challenge, which was not his to deny anyway, and then proceeded with the trial. I've got the trial posted in the group too, if anybody wants to listen to it. I had just listened to Fountain's stuff a couple days beforehand, and I knew how his Star Chamber hearing went, and so I had no illusions that things were going to happen appropriately. My attitude with all of this was I knew they were going to violate rights. I just wanted to know how many, in what ways, and how it could resolve. And since Brett's stuff, like Brett's way more experienced than me, and he went in there, they violated his rights all over the place, and then he got it dismissed on appeal. And the thing that they used to dismiss was the simplest, like most clear-cut, they didn't have a charging instrument according to the Constitution thing. And I realized that they have to do that because if they don't, then they have to get into every other thing the court does wrong. And that's a can of worms that they refuse to look at. So I was like, okay, what can I get them to do wrong? And I tried to put together questioning that I could use to get as much evidence on the record out of the mouth of the other side that I could use later on, so that it's not me saying XYZ, it's the cop, or it's the judge did this thing, and this is I've got a estoppel, like this is the claim the judge made. Like you can't take a different position now. That's the position. You've already got it.
Mm-hmm.
So that was kind of the way I did it, and I also read through all of the rules of evidence, because the rules of evidence are, again, they're not in the court rules. They're a separate rule that you need to know, and those apply and are very, very helpful when you get clear on what they are. What can a witness testify to, and what is a witness? Because what these courts do, specifically with the police show up in uniform, and it's no different than a doctor in a lab coat. They put that on because it gives the appearance of authority. It gives the appearance of expertise. They don't have expertise. They are not expert witnesses. And as a non-expert witness, they can only testify to things that they have personal, firsthand knowledge of. That is, according to the rules of evidence, that's the only thing that they can do. They can't know things that are unknowable. They can only know things that they know. And if they testify to other things, it should be stricken as outside of their, their personal knowledge. It won't be, but it should be as a matter of law.
Now, did you go in and try to do any special appearance stuff, or you just? I mean, they had you in custody, so probably didn't matter, right?
I was told in special appearance at all of the hearings that I attended, and that was one of the things that pissed me off. Like, that was one of the things that had them thinking that I was, this is a sovereign citizen guy. Like, at one of the hearings that I went to, the woman judge, as I was checking in with her little secretary, clerk, whatever, the one that's in the courtroom, I go in there and I'm identifying myself. And years ago, I would be, I'm not all caps name, and I'm not this, and I'm not that, like all the patriot mythology stuff. But as Alphonse has pointed out many times, and as I've like really come to internalize a lot, they can call me a donut. It doesn't make me a donut. Whatever it is that they say, like, jurisdiction exists or it does not exist. It can't be imagined, like, it can't be granted by imagination. It's not magic. It's not like if I say the wrong thing, suddenly they have authority over me. My rights come from God. That's it. They don't come from them. They don't come from a paper. They don't come from, the government, whatever it is. But if I don't know where my authorities come from, then I'm, maybe I'll look, maybe I'll accept something that I wouldn't. So by knowing that it doesn't hurt if I just say, you know what? Yeah, I'm here for this. This is the matter I'm here for. That this is who I am. I did it that way. But as I was checking in, and as I was telling the clerk inside that I was there by special appearance, the judge suddenly perks up and wants to be involved, like, well before anything is on the record or whatever else. She's like, "You can't do that." And I was like, "What are you talking about? Why are you special appearing?" And I said, "Well, because I don't acknowledge the jurisdiction of the court. I'm challenging the court's jurisdiction." "Well, you can't challenge jurisdiction. Are you a lawyer?" Like, why would I have to be? Is there some statute or rule that says I have to be a lawyer to challenge jurisdiction? And she of course didn't answer that one. But
because if so, we were going to investigate discrimination at this point. Because if there's a special club you have to be in to appear in court, then we want to know about it.
Yeah, like, if there's a rule that I have to follow for this thing, tell me what it is so I can. Of course there isn't.
Right.
And she threatened to have me arrested at that hearing for a failure to appear because I was appearing specially and not generally. Like, it's wild in that particular municipality right now. And my goal with this particular hobby of mine of the law stuff is to rein them in quite a bit, because in the other municipality, they didn't care. You're appearing specially. Okay, cool. Do it. Get it on paper. You're here, so you're here. They didn't feel the need to try to strong arm me into saying things in a specific way. Like, and they dismissed the charges when it became clear that they could not justify what had occurred. So they're like, you know what? We'll dismiss everything. Don't look any closer. That's kind of the vibe that I got. Don't look any further at this point.
So you think somebody might have got there before you did in that municipality, and then the one you're fighting, you might be the first guy?
I think so. I mean, the impression I have, and like, just for a little bit of history. So Chandler's been a good sized suburb for decades. It's one of the biggest suburbs around. Gilbert is a town, and it has grown a lot in the past, like, 15 years or so. But it's like 20 years ago, it was a cowboy town. Now it's quite a bit larger, and there's quite a bit more stuff going on. But I suspect that they have not felt the wrath of a well put together 42 1983, but they're gonna. we'll just put it that way.
Yeah, good for you. Yeah, these courts, my right. The biggest step in this whole process for me was determining who I am, right? And where your rights came from, which you just talked about. And once you determine that, then you put them in their place. You're tasked with protecting those rights of mine. That's what your job is, not to violate it. And so once you put all that in perspective, you get a little more confidence, and then you're not so worried about what you're saying because you know how it's supposed to flow, right? And then all the details can work itself out with the rules and all this other stuff. But knowing that solid core to stand on, that rock to stand on, is what is the biggest task with starting anything of this nature.
Yeah, and to add to that, when you're rooted in truth, you don't have to keep a lot straight. Like, speak what you know, and don't speak other things. One of the things that I noticed when I was talking with the defense attorney that was temporarily assigned to me, he kept making all kinds of claims that he had no evidence of, all kinds of stuff that he could not back up. He's reading the notes from the police officer to me. Well, he says blah 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 blah, and I'm like, I don't care what in my mind, I don't care what he says, because he can't back any of that up. He doesn't have any evidence of any of that stuff. And I'm like, I pointed out to the attorney, I am being very particular about the words that I use, and I'm only speaking things that I have knowledge of, or that I have firsthand read. I read this in the Constitution. It is there. I'm not I'm not making something up. I'm not claiming that due process is being followed because AJ says so. No, due process is clearly delineated. If it's not occurring according to that clear delineation, then it's something else. I don't know what it is, but it's not due process. So, these guys and the attorneys are doing it all the time. They're doing what they're trained, they're doing what they think, but they're not rooted in truth. And because they're not rooted in truth, they are ruthless. When you know where the foundation is coming from, just say what you know. Don't say anything else. And by not even, I don't think that I have made any proactive claims in the matter at all. The only things that I've been doing is poking holes in their stuff, because I don't have to make a claim. I don't have to say I have a right to travel. I may not, but they can't prove that I was transporting. They can't prove the code applies. They can't prove that they did things according to their rules. And by me just sticking to the truth of, I know that your rules say what you must do and you didn't do it. You don't get to convict me of something when you didn't follow your own rules to get there. I don't care what the other stuff is. Like, when you read all the case law, stuff gets overturned. It's like the convictions getting thrown out are not for people driving on a suspended license. They're murderers. They're rapists. Like, these are not good people. And yet the same precedent that allowed Miranda, a rapist, to go free because of violations, well, I didn't do that. I was driving, minding my own business. And I use that driving colloquially. I'm not speaking of a statutory term that applies to transportation.
Of course.
Yeah, sorry. I get a little. It's funny because we say we don't. We're not the villains in the story, but the people who actually have done horrible things, they get away with it because some high-priced so-and-so goes before the court and writes it in the special code, and then they look at it and they're like, oh, this guy's got really nice cufflinks. We better let him off. We go in there and they're like, what? You think that you have rights from God? Get this guy in jail. Don't let anyone else hear him. Punish him. Punish him. That's
right. Unbelievable. So, what is the next step in this case that's ongoing?
So yeah, in this case, it's ongoing. Just to provide a little more at the trial, I put together questioning that I was going to use, and my goal in that was to disqualify the witness, to prove that he doesn't actually get any training on the transportation code that he was utilizing, that he was enforcing.
Right.
Because if he doesn't know the scope of the statute, how can he know how is he able to differentiate between a statutory violation and a non-statutory activity? He doesn't know the statute. He doesn't receive any training on what activities are covered and what's not covered. So all he's doing is coming up with his own opinion on it. I wanted to get just different things on the record that I could use for later. I mentioned that there's a crime. There's a crime in Arizona that if someone is in custody, the police, it's a misdemeanor for any police officer or whatever to use like I wish I had it. It's like harsh tactics or something like that. Like essentially, they can't threaten, they can't harass. There's a lot of things that they can't do to get evidence of guilt from someone who's in custody. And so I have him testifying that he was seeking evidence from me and he was threatening me with jail, hand on gun, 5 cars around me to try to get that evidence, which by itself is an Arizona criminal violation. That'll be one of the criminal violations that I file. But I wanted everything from the mouth of the party themselves, not like me just alleging it. Ultimately, the judge convicted me at the bench trial. The They never established that the statute applied to me. They never established that that the officer could testify to things that he testified to. And when I moved to disqualify him as an expert witness because he had never been qualified in the first place, they didn't allow me that, even though the rules of evidence allow for expert witnesses to be qualified, like qualified or disqualified. I brought up the specific rule, the judge overruled it and continued on. When the prosecutor was trying to get things into evidence that were, didn't matter, I objected, they were overruled. When I was asking things that did matter, that brought to light improper training, lack of training, etc., the prosecutor objected. The judge immediately sustained their objections without giving me opportunity to get my factual basis for the objection on the record. It's just it's Star Chamber stuff. It's just they're making sausage and they don't care how it gets made. They're just shoving stuff.
Yeah, it's
but
a lot.
I objected over and over.
A lot of arrogance. When we've always done it this way. What are you in here telling us about the rules? We do these rules every day.
Yeah.
Don't tell us about that.
How dare you think? How dare you think that you know anything?
Right. Well, I'm sorry. We're going to start messing with your revenue stream, and you're going to have to think differently. That's just how it's going to have to be.
We're changing things a little bit, sir. So I actually moved to have the charges dismissed when the prosecution wrapped up their case because they didn't actually prove all the elements. Like they missed fact elements, but of course the judge doesn't care, so he ignored that part, didn't allow for it. And then when it was my turn, I testified briefly that I wasn't engaged in transportation, that got some facts on the record out of my mouth that I thought to be necessary, and then realizing the error of his ways, the prosecutor, because he didn't get anything on the record to actually demonstrate that I was driving, operating, motor vehicle, like all the things that establish factual elements according to their statute, he tried to get them out of me, and he wanted me to testify to things, and I recognized what he was doing and realized that I was ignorant of stuff like, my property that I was taken from point A to point B, it has wheels, yes. Is it capable of this? And I realized what he's trying to do. Is it capable of self-propulsion? I'm like, I don't know. You don't know if it's capable of whatever. And I'm like, I don't have firsthand knowledge of that stuff. Like it has internal combustion engine. I don't have firsthand knowledge of that. Like I know that I can get in my property and I can take my property from point A to point B. The magic that operates besides, I don't have personal firsthand knowledge of, and I can't testify to things that I don't have personal firsthand knowledge of.
Smart.
He moved to have me deemed not credible as a witness because I claimed to not have knowledge that my property was a motor vehicle. And I realized that type of thing, like if they can use that against us in the future, I'll use that against them. Like, get the officers to testify to that. If he claims that my property is a motor vehicle, how does he have that personal firsthand knowledge? Did he witness whatever? Where did he get the information from? And if he can move to have me declared not competent to testify, well, then I can move to have somebody else declared not competent to testify.
A perfect example of how they use language to trick everyone, driving being a commercial term. And in Louisiana, I think the term you have to refer to your It's an automobile. That's the
Mhm.
one that's left out of the statutes, right? And in other states, it's car or whatever. They
Yeah.
change the language by state, but there's always one term that would cover your property that is not in the transportation code, and they always
Yeah.
just leave one out, and it's just a bunch of nonsense. It's a bunch of
Well, and
nonsense.
specifically with the transportation code, the thing that I found that was very useful and that I at least for my comprehension, um, the statutes are currently how they have interpreted and revised the stuff to apply. Like that's what they do. They put it together. They make it easy to find a code, for example, right? But the statute isn't what was passed by the legislature. And so I went back and I found the actual act that was passed by the legislature. And when you reference the act that the legislature passed, like these are the representatives, this is what they said. Their intent was clearly and strictly commercial. Everything that's happened since that time has been administrative in nature, and it's fine that they're making administrative adjustments. But if the legislature didn't pass it as a law, all the stuff afterwards is administrative interpretation only, and it doesn't change the legislative intent. So, like, it's great that they have automobile excluded from the list, but when you go back to what it was, it is so clear reading what they actually passed. Nobody can misconstrue what the purpose was. It's only by deliberate ignorance that it's been allowed to proceed, and that was kind of the line of questioning. One of my line of questioning that the judge allowed um, as I was going through it. I was asking the guy about training he received or about the law as passed by the legislature in whatever, because I don't really care what the stuff is in between. you know if the legislature gets together and they decide that it's against the law in Arizona, and we all agree that it's against the law for anybody to paint their house blue, and they pass that, and everybody knows you can't have a blue house, so all blue houses are off the table, and then somebody's like, well, that purple is kind of blue, and green contains, and so they start adding all these little things in. Well, that's not what the intent was. The intent was the intent, and we can't change it after the fact because we want to use it against somebody else, but that's what has occurred.
Right. And so, have you read the municipality section on American jurisprudence? Have you
I
read
have
that?
not.
Okay.
Uh-uh.
That was very enlightening to me, and it may be helpful moving forward in your other cases. But it clearly lays out the revenue scheme by the traffic motor vehicles and the municipalities and all this nonsense, and it really puts things in perspective and gives you all the case law, of course, and that's posted in the AMJUR of the document resource section. But it's very enlightening for anyone that is dealing with these things to go read how the municipality works. If you're having some particular issue with garbage pickup or whatever, go read the municipality section, see how they operate, see how they're supposed to operate, and it makes it easier to find what you're looking for to convict them.
Right. Yeah. I suspect I'll be using that stuff more when I'm on the offensive.
Sure.
For my defensive, I'm kind of using as a foundation the things that others have done,
Mhm.
but I'm trying to see if I can resolve matters without going proactive, if that makes sense. Like
Right.
my goal and intention is, can I get these matters wrapped up and adjudicated in my favor using nothing but what they do wrong, what they do not do, are required to do. And so far, one matter's already gone. The other matter, I was convicted at the bench trial, even though the judge in his deliberations, he came back and he presented that he was trying to do me a favor by seeing if there was any evidence presented that it occurred within the geographical boundaries of the municipality. And it turns out that it was, but if that wasn't on the record, boy, he was gonna let me off. And I'm just like, I never called him Your Honor, and I never called any of the judges Your Honor because they did not display any honor to my perspective. Like I called him Judge. I would have called him by his first name, maybe that would be next level. But I'm just like, this piece of garbage is up here pretending like he's doing something right, knowing full well that he's doing so much wrong. But he convicted me. I immediately filed the appeal and had them refund all of my bond money because, like, the purpose of the bond is to get me to show up. I showed up. Well, you convicted me, so now here's my notice of appeal. And by filing that, it also put a stay on all of the punishments. Here's the fun with this one: the punishment was $100 fine, which was waived because I was arrested and jailed overnight. Then I went back into custody. Then the judge that the trial was before had me put into custody again for not acknowledging jurisdiction. So to my count, that's 3 days jail, 2 days, best case for a matter which allows for $100 of punishment. And the
Revenue.
good news is, well, the fun thing is, there's the rather famous case, the Trezevant versus City of Tampa. The specifics of that matter: he was pulled over for a traffic thing. He didn't want to sign the promise to appear. He instead was going to post bond, and instead of bringing him to the department to post the bond, they locked him up. They put him into holding for 20 minutes and then let him post bond. Like, his matter and mine are virtually identical as far as what happened, except I was also assaulted and I was also jailed multiple other times. So I don't know if I can, create some precedent or if that one even matters. But I was jailed jailed as punishment for a crime that allows a monetary assessment fine only. It does not allow for other things. So that'll be going into the false imprisonment stuff that goes against them. And I'm in the midst of preparing my memorandum for appeal, just to add a couple of additional details. I'll probably get that filed Monday. I got my daughter's not here; she's with her mom this weekend, so I can get some other stuff done.
Well, Monday's a holiday, but
Tuesday.
I'm going to, if you would, I'm going to give you permission to post in the document resources group. If you would go through and find your audio and your videos, I'm going to create a topic in there for hearings. And
Okay.
if you would post it in the hearings, I have a couple I need to post in there as well. But we'll put it there, be easy to find for everybody, and then they can go look in sequential order and kind of follow along if they choose to. Because I think seeing real life interactions and hearing them probably help a lot, calm the nerves at least when you walk into the courtroom. So trying to get as much exposure out there for people that want to find the resources. But anyway, anything else we need to cover, or are we wrapping this up, or I'm gonna give you the last word if you want it.
No, we've covered quite a bit, and the audio seems to be the piece that everybody has enjoyed the most of the hearings, because it is very nerve-wracking going in there, and if you don't know what's going on, if you don't know where your standing actually comes from, like that's one of the things that the Patriot Mythology groups really they do a disservice to everybody by bringing to light the existence of standing. Like, we do have standing as men, as God's creation, except we're taught to think that, well, I have to change my standing, I have to fix my standing, I have to do this. No, like, you have to know who you are, and you have to know where that comes from. And once you know that, everything else falls in line very easily and very cleanly. And once you're again standing in that truth, it all gets really easy. And I'll post all of the audios in there. I'll put them into sequential order. But that stuff has been what a lot of people in the Alphonse group have really liked, because they can hear, what's likely to occur,
Right.
how it probably will go down.
And there's so many things they can throw at you in there, and if you've heard it before, it's going to be a little bit easier, and that's what that's our goal is.
Yeah.
Well, if you want to wrap it up, or we're good. All right.
I don't know if I have any other wisdom.
Well, I'm going to say thank you for your time today. Thank you for sharing. Thank you for willing to post all your stuff in the Telegram groups, and I'm sure that everyone is going to tune in and know a little bit more than they did yesterday.
hopefully that's all of our goals. Thanks, Gary.
Thank you.